unreleased deeds of trust or mortgages, depending on what state that you are in. Now the viewer that hears that is probably thinking, okay, how is that even possible? How does that even happen? How can a title company let that happen? Sean, why don't you explain that process and give some context as to, one, how does that happen? How do we see that happen in Arizona? And then what are the steps we have to take to fix that?
So one common scenario, like you said, is the loan payoff is delivered to the title company. Title company delivers it to the lender. It's a traditional lender, and they receive it and they don't do anything with it. They just accept the money and show the loan is being paid, but they don't record the deed of release and reconveyance. So it happens a number of ways. Number one, remember these servicers are large and they're servicing hundreds of thousands of loans at any given time. And some of them have better procedures than others. The money goes, and then somewhere along the lines, there's a break in the chain of command or the chain of tasks, and a deed of release just doesn't get recorded. Other times, it could be that they're in the process of a servicing change because, these notes are bought and sold on the open market, and you could have a servicer for a year and then you get a new servicer, and then you have that service for a year or two, and then you get a new servicer. Well, it could be that the payoff was delivered like right in the middle of that change. And so, of course, who's going to release? The new servicer or the old servicer? And one thinks maybe one's doing it and the other thinks someone else is doing it. The old servicer, they may not want to waste the time releasing it because we're not getting paid anymore. Our job is done. But then the new servicer may not release because they're saying, well, we didn't get the money. The old servicer got the money, and so we got a zero balance loan. Like, why are we going to do it? We're not getting paid either, right? And so nobody wants to deal with it. Bottom line is the loan's been paid, but you have a deed of trust out there that's still showing a record. And so when you go to sell the property, what do? You open escrow, and the title company runs a title report or a commitment for title insurance. And on that, it's going to show, hey, there's this deed of trust out there that's not been released. And so then you say, well, wait a minute, that was paid off and I have proof. Well, unfortunately, it's not just that simple, right? So there's a couple of options available to resolving that specific scenario, which, like you said, happens more too common than we would hope.
Well, and I think it's important to note too that I think a lot of people think that maybe they wouldn't be familiar with this term, but like a condition to close. The lender recording a deed of release and reconveyance in the context of a deed of trust is not like a condition to close that they do it right then before closing, like that. Correct. It's recorded. Obviously, it is a condition that they do that and they're required to do that, but they've got time to do that, right? And that's a little bit part of the problem.
Yeah. So what happens is on an escrow. So let's say you have a loan with a deed of trust or a mortgage that you do owe money on. So the way it works is you open escrow, and then the title company or the closing attorney goes to the lender and says, or the servicer for that loan, and says, hey, what's the payoff? How much is that? And the lender and the servicer submits the payoff to the title company or the closing attorney, and they get that payoff, and it says, hey, if you pay us in the next generally 30 days or 14 days or whatever date they put on the payoff, this is the amount that you need to deliver to us, and we're going to call that good, and the loan will be deemed paid in full. And then, so what title does is they, by law, have a right to rely upon that payoff. That's a valid document that they can rely upon. And so title goes and they close and they cut a check to the lender or the servicer for that amount. And when that amount is received by the lender or servicer, by law, both federal and state law here in Arizona, the lender has 30 days to execute and record. So it's incumbent upon the lender. it's not incumbent upon the buyer, the seller, or the title company. It's the lender's responsibility by law to record what's called a deed of release and reconveyance, which basically says we release our lien or our interest in the real estate. And so they then record that, and they have 30 days to do it. Well, what happens if, like I said, in those 30 days, servicing transfers? Well, who's then going to record it? I don't know. Or there's a break in the chain of tasks, or somebody leaves. It could be somebody's like, hey, I'm out, like I found another job. And so, that was one of the people responsible for recording these deeds of release. And then it just is lost in the shuffle between, one employee leaving and another employee taking over, right? It could be as that simple. It's not nefarious. They're not purposely not releasing. It's just some breakdown somewhere. And, these are large servicers with hundreds, if not thousands of employees. And, they're doing a high volume. And so, yeah, it's just a breakdown there. And something happens. And so to your point, yes. So what happens is they don't record within those 30 days. 5 years goes by. And then all of a sudden it's like, oh, I'm ready to sell this property. And you go and you open escrow, and the title company runs their report, and they say, oh, well, this loan is still showing a record. You're like, wait a minute, I paid that off. So there's a few options there when that scenario happens.